Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode. All right, friends, we are back in Murray, Calloway County with workers' compensation attorney Jeff Roberts, and we're going to talk about injuries to temps and interns. Jeff, how you doing, guy?
I'm doing good, Jim. How are you?
I'm doing well. Always good to see you. Let's jump into this. I know in the past we've talked about things like injuries to minors. We've done an episode on that, but I think back in episode 77. And these are, this is just another classification here that you don't really think about that, wow, am I covered under workers' comp? The good news is, yeah, you pretty much are.
Yes. If you are an employee, you're going to be covered under workers' comp in most instances. There are, like agricultural workers are exempt in things of that nature. But like if you are a temp worker at a company and get injured, then you are still covered under workers' compensation. Now, in that situation, the company that you're working for is not going to be the defendant in the case because they're not your employer. The temp agency that sends you the paycheck is your employer's. That's actually going to be the defendant in the workers' compensation claim. That's going to be whose workers' compensation insurance carrier has to pay you. And that can cause some issues. I know we've talked in the past about the requirement to give notice to your employer. And I think it's good enough if you're placed there so if you're placed at a factory and you're working at the factory, and then the supervisor that's actually works for the factory and you're working for a temp agency, and you tell the supervisor that's over you about it, I think you're probably good enough. I have seen them try to make an argument, well, you didn't notify your true employer, but they have kind of made that supervisor the overseer of you at that, and I don't think you're going to lose that in Kentucky anyway.
And real quickly before we move on, do you want to talk about that duty to notify? Because I think this kind of shocks a lot of people.
Yes, in Kentucky, when you're injured on the job, you're supposed to give notice as soon as practicable after the injury occurs. Now there are some ways to massage that, so to speak, and that is, a lot of times, frankly, if you work at a factory where you're lifting heavy weights all the time, you're going to have sore muscles. And so if you lift something and your muscles are sore when you get done with a really strenuous day of lifting, and you think, okay, this, I've used muscles I'm not used to using, or did a little more, muscles are strained. It'll go away, just like if you go to the gym and you hadn't been in a while, your muscles are sore the next day, and goes away over time, nothing major. And then 2 weeks later, 3 weeks later, it's still going on, and you say, okay, maybe I need to get this seen about. That's fine. The law says, yeah, we understand that situation. Until you realize you're injured, you don't have to give notice, as soon as practical after you're injured. From that standpoint. So it doesn't mean immediately you've got 1 hour or 24 hours, as some companies try to say.
Yeah, we've talked about that. Yeah. It's a policy. It doesn't matter. Kentucky law is
the law is what matters, not the employer policy on whether you're covered under workers' compensation or not. From there, so. But you have to you've got to give notice even if you're a temp worker. From there, but it's going to be the carrier for the temp agency that you're working for. That's their workers' comp is going to be liable. Another quirk in Kentucky, which I wish they would fix, and they still have not fixed it.
I'm going to start making a list, Jeff, because it seems every episode we come up with Jeff's going to fix something here.
Well, if they would start listening to me, the world would be in a whole lot better place.
It's a free podcast. I don't know what they're doing.
I agree. But what has developed in Kentucky is, I don't know if we've ever actually talked about a safety penalty, But if the employer violates a safety statute, then your workers' comp benefits can be increased.
This is such as an OSHA standard or something.
Yes, yes.
Okay.
If they violate OSHA, but if you're a temp worker placed at a factory and the factory violates, and the factory is the one who violates OSHA, that's not your employer. So your employer is not committed to safety violation, and you don't have you don't get the increased workers' comp benefits for that safety violation from that standpoint. And frequently, the way it's worded is they're going to still get the employer is going to get the protection of the exclusive remedy provision. So you can't sue the one who committed the OSHA violation, the factory, civilly, because they get the up the ladder exclusive remedy provision, and there's no avenue for that.
That was some high-tech legalese there.
Yes.
I just wanted to point that out.
Yeah. And sometimes I got to show off my legal training.
Look at that.
I got to use the big words. So there is some of those issues that come into play from there, especially from the temp agency, because some people work for a temp agency for years.
Oh yeah,
they
absolutely.
get placed and they work for an employment agency, a temp agency, or employer organization, whatever they want to call them now, and so that can make a big difference from those perspectives. The other side, as you mentioned, is the intern, and that creates a little different scenario. Because if you have an unpaid intern, well, workers' comp benefits other than the medical side, but the benefits to the workers based on their average weekly wage, which we've talked about in one episode in great detail. And that, so if they're an unpaid intern, there are no wages there. But as we talk about, I believe in that episode or in another episode, if you have two jobs, then you combine the wages for both jobs. So if you're an intern, unpaid intern, and you're working, I've had during my career, I've had some Murray State students who've interned at my office on occasion, and I know some other law firms and the judges and all have had students who've interned for credit at the university. They're not getting paid, but they're doing it for credit from that standpoint, but they work somewhere else as well. They have a job that they're actually are working and getting paid for. And in that situation, then, if they're injured as an intern, if there is a true employment relationship, and that's the other side of it, is there a contract of employment with them. But if there is a contract of employment, then the intern would get workers' comp, and you would use the wages from their other job to determine their pay. If that's the situation, if it's an unpaid internship, it's paid internship, you would combine the wages.
That makes sense. Now, and Jeff was referencing actually episode 77, titled "How Are My Workers' Comp Benefits Calculated?" And we go into really the difficulty sometimes of actually determining what in all reality is the average weekly wage for that employee. And Jeff, as you just said, if you have a second job, a lot of times that's going to be counted in there as well. So it's important that if you are injured as a temp or an intern, that you talk to an attorney, because there are a lot of things you may not be thinking about that actually you could be that could go into the amount of benefits you're actually going to receive.
True. And another thing that comes into play in both of these settings is, sometimes you have some companies hire temps on quote unquote a probationary status. They hire temps, and then after they've been there for 2-3 months, then they make them an employee if things are going well and they don't have a lot of absences or whatever. They make them an employee of the company, and their pay goes up when they do that. Or with an intern, even if it's a paid internship or even an unpaid, it's you intern here for a period of time, and then this position's opening up, you intern, and then we'll transition you into that type situation if that's the case. Or if you've got any type where you're doing an apprenticeship thing, or you're sort of in a training period, which kind of encompasses all of them. If you're in a training period and then your pay is going to go up, once that training period or that apprenticeship or whatever is over with, then that can be taken into account. Kentucky law does provide for that. So if you're injured during that training period, apprenticeship period, and at the end of that apprenticeship, your pay was going to go up $4 an hour, then on the workers' compensation benefits, that can be taken into account. And that higher average weekly wage that you were going to be getting once the training was over with is what would be applicable for determining, for calculating your workers' comp benefits and for the pay while you're off work.
And again, that's the reason why you want to talk to an attorney, because again, you may not be thinking about that. And I think in previous episodes, you have mentioned that these average weekly wage calculations are sometimes done incorrectly. And it's a matter of really going back and going, wait a minute, let's check the math here a little bit, and let's make sure that we're figuring all these things in. Not that they're doing it on purpose, but it is complicated.
It is complicated because certain things are included, certain things are not included. Their overtime hours are included, but not at overtime pay. It's at straight pay, so you can't just go, all right, I got paid this amount this week, this amount that week, and it's averaged over a period of time. If you get a per diem, how does that affect it? If you get a production bonus, then a production bonus is added to the average weekly wage. A profit sharing is not added to the average weekly wage calculation. So it's a very complicated aspect of how to do it, in what is added in, what's not added in to the calculation from that perspective. So frequently I do see when I get the wage records and I calculate it, they have miscalculated the average weekly wage. Occasionally to my client's benefit, rarely to my client's benefit from that standpoint. But I do think most of the time it is, because when I look at it and I explain, you didn't include this in there that should have been included or whatever, most of the time they correct it at that point. I think a lot of it is just, frankly, the person who's doing the calculation doesn't know what's included there. And frequently, sometimes it is the person who fills the paperwork out to send to the insurance company for the employer doesn't know everything they're supposed to be included in there. And then when I get the wage records from my client or get the raw data after I request it, and do that and then point out and say, well, they didn't include the production bonus my client got when they sent you the wage records. They just did the hourly rate and the hours work, not the production bonus, and that should be included in things like that. So it's usually, I think, an innocent mistake.
I was just thinking, I could imagine, if you're in a sales capacity and you're highly compensated on commission, some kind of incentive-based income stream, this would be very, very complicated because you're not getting a straight pay most of the time. It's what'd you do this week or this month or that quarter.
Correct. And yeah, I see it there. And you can, it depends on, there's a lot of different situations where that comes into play.
Yeah.
From there. And, one that I've had to deal with a time or two that we've mentioned before we started the podcast, that's kind of somewhat along the same way with an unpaid intern is volunteer firefighters.
Yeah, I was looking forward to getting into this because I know some volunteer fire department people and yeah. So if I'm injured as a volunteer firefighter, how does this work out with average weekly wages and things like that? You
look at the average weekly wage of the most volunteer firefighters have another job, and that's the average weekly wage that you use is because, obviously they're not getting paid for the firefighter work, but it's based on what their average weekly wage is in their normal regular employment. So the benefits would be paid based on that. So, if I worked as a volunteer firefighter, well, I'm not a good example because I don't get paid wages. So if one of my staff members worked as a volunteer firefighter and they were injured carrying out their duties as a volunteer firefighter, then or volunteer rescue or whatever, then they get workers' comp, and it's going to be the workers' comp for that department that they're working for. there, but it's going to be based on the wages they earn at my office.
At their full-time job, basically.
Their regular job is how that's going to be calculated. So you may have one who's makes $400 a week and one who makes $800 a week working side by side there, and both get injured. One's getting paid based on $800 average weekly wage. The other's getting paid based on $400 average weekly wage. So.
I hate to say it, but it's all math at that point. You're
Correct.
looking at all the factors, and this is what the law says. So
Correct. Exactly.
That makes sense. Jeff, let's come back to this. You mentioned this earlier in the episode, the contract for employment, and I think this is when we were dealing specifically with interns.
Yes.
But why is that important, and kind of how does that factor in?
Workers' comp is based on you have to be an employee to receive workers' comp. So if there's not a contract of employment, then you don't get workers' compensation. For instance, if you are in jail, and they, sometimes they go out and they clean the highways, do that. And thankfully, I visited clients in jail. I've never personally been a guest of the jail.
Well, I saw "Oh Brother, Where Art Thou?" So I'm relating here now.
So, but from my perspective, I would rather be outside doing something like that than sitting in a small cubicle cell. And so, but if they're out there, they're not an employee. If they get injured out there, they're not entitled to workers' comp. They're not an employee. There's not a contract of employment in that situation. I've had some interns come in, and it's just, I tell them, they've got to do a certain number of hours over a certain period of time. And I, you come in when you can. If you got a test due that you need to study for, that's fine. We're open this period of time. You come in when you can, and when you're here, I'll work with you on stuff and show you and let you, shadow me type thing, and we'll keep you busy. But they're not really, it's not really an employment type situation.
Right.
There, and I think if they got injured in that setting, I could probably argue, okay, they weren't an employee of mine, they shouldn't get workers' comp. If I wanted to make that argument. Whereas if it is, okay, you're an intern here, but you've got to be here, be here at 8 o'clock, you're here till 8 to noon every day for this period of time for this internship, then they are probably going to be considered an employee in that situation where where they're what they're doing and when they're there and who's controlling, and there's a much more control by the so-called employer versus the intern themselves. Then that makes a difference because you have to have that contract of employment for there to be workers' comp. One that comes up frequently is like an independent contractor.
That's
situation.
what because I know we've talked about that in previous episodes, where an independent contractor is not necessarily an employee, so they may not have eligibility for workers' comp if they're
they do not have eligibility for workers' comp if they're an independent contractor. From that, like if I have someone come in to work, my copier goes down and I have someone come in to work on my copier, I'm paying them for that. For the job they're doing on that, but they're not an employee of mine. They're a vendor, so to speak, or an independent contractor. They're not covered under my workers' comp if they got injured on the job. If they lifted part of the copier up and injured the back, they wouldn't be covered under my workers' comp. Now, if they worked for Xerox or another company, then they'd be covered under that one, but they wouldn't be covered under mine.
That makes a lot more sense to me. So really, that contract of employment is extremely important, and it's one of those papers that you need to keep for a number of reasons. But obviously, if someone were to be injured, that's going to be a valuable piece of documentation for you, I would think. Jeff, let's talk a little bit. I know we're kind of getting into springtime here, but let's talk about seasonal employment. Mm-hmm. So again, I might be a part-time person, or maybe I'm full-time, but I'm seasonal, right? So how does that come into play with workers' comp?
You're still covered under workers' comp. If you're an employee, you're covered under workers' comp in that setting. But again, you get into the calculating the average weekly wage. And that's a lot of these, they come back to that issue. How do you calculate the person's average weekly wage? If they're a seasonal worker, well, they may make, during that season, they may make good money, but if they're injured at the very first part, because workers' comp benefits normally are you go back over a 13-week period of time, or the prior 52-week period of time, and break it into 13-week quarters, but you have to be there for 13 weeks, etc., to calculate the average weekly wage. Well, if it's at Kentucky Lake, we got some marinas that they don't have the employees there during the winter time type setting. The owner can do everything that's got to be done or something of that nature. Well, if the person gets injured the first week, well, they don't have 13 weeks of employment. Whereas the exact same employee, if it was injured 3 months down the road, then they do have 13 weeks of employment. And so how do you calculate the average weekly wage? And the statutes do take that into account. And basically what you do with the seasonal employee is you take the wage that the worker would have made, basically the total wages that they'd earned in the 12 calendar weeks, divide that by 50. I'm assuming they think, well, people get 2 weeks off a year, so they're dividing by 50 instead of 52. And that's how you calculate the average weekly wage for a seasonal employee. They're still covered under workers' comp. Doesn't affect the medical benefits. Medical, same whether you're temp, intern, but there is a contract of employment, seasonal employee, volunteer firefighter. Medical is all covered. There's no copays, no deductibles. How much you receive if you're off work under doctor's orders. How you calculate the average weekly wage becomes a very huge factor in those settings.
And I think people don't really understand that is a significant factor there. It's not just the medical bills. I mean, there's a lot to workers' compensation benefits. I mean, we've even in the past talked about vocational rehabilitation opportunities. Depending on if you meet the criteria. I mean, there's a lot to workers' comp, more than just having your doctor's bill paid.
Exactly, there is. There's a variety of different benefits. One is obviously the medical side of that, which continues into the future as long as you don't let statute of limitations expire, would continue for a minimum of 15 years, potentially lifetime. And then you've got, if you're off work, then you get paid a workers' comp check called temporary total disability. And if you have, and you may, depending on the severity of the injury, even if you're back doing the exact same job, earning the same wage, you still may be entitled to permanent disability benefits. If you can't go back to doing the job, then permanent disability benefits are going to be greater. And if you can't go back to doing the type of work you've done in the past, then we can look at getting you retrained into another field, or potentially, if you're totally disabled, obtain permanent total disability benefits for you in that setting there. So there's a variety of benefits that you can recover under the workers' comp law.
And you mentioned disability at the end. If you're totally disabled, you've got that option as well. At your practice, though, you handle workers' comp, but you also handle Social Security disability, and that's another option that may come into play, correct?
Well, yes, it's another avenue that could open up. It doesn't mean you've got one or the other.
Right,
you can
right.
pursue both.
At the same time, actually.
At the same time, yes.
Yeah. Okay, well, Jeff, I mean, that's it. When we talk about these things, I love the fact that we're breaking them down and we're trying to make them understandable. But there's no getting around it. The law is complex. It's complicated. There's a lot of factors to take into play and take into consideration. But you've got 32 years of experience, and you've practiced primarily out of your main office in Calloway County, there in Murray. But you've got another office up in Christian County, up in Hopkinsville.
Correct.
But it's one phone number to get a hold of you, right?
Yes. The best way to reach me is by phone, and the phone number is 270-753-0053. You call that number, you'll have a live person answer the call. And, well, if it's during business hours, you'll have a live person answer the call. And if I'm not available, they'll get me a message. If I'm available, regardless of which office I'm at, they will let me know, and then we can. If I can't talk to you, I will talk to you. Then if I can't, then they'll get a message or get some information, and we will follow back up later.
Right. And as far as workers' comp claims go, you can handle workers' comp all throughout the Commonwealth, right? So pretty much any county in Kentucky, if you're injured, you can represent that individual.
Yes, I handle cases throughout the Commonwealth of Kentucky, and I have cases right now going on. I've got clients in Louisville area, up in the Lexington area. In fact, fairly recently, I met with a client up in Louisville to get some paperwork signed, talk to them about their case when I happen to be up at Louisville on business. And so, yeah, I meet with client. If the client is far away, we can do it by phone. We can do it by video conference. But I travel to Bowling Green frequently. I travel to Louisville frequently, Frankfurt, and usually I try to kill two birds with one stone. So if I have to come up to Louisville for some meetings on one matter, I'll try to set up appointments with clients as well while I'm up in Louisville for that. And so I do that for that reason. So, because I do like face-to-face communication, which we can do to some extent through video conference. We can at least see each other, and I can see the expressions and know if, sometimes when I'm explaining things, I try to not speak in legal speak, and but sometimes I can, if I'm seeing the person's face, I can realize, okay, they don't seem to be quite understanding, and I know to try to rephrase it, reword it, explain it a little clearer for people. And normally when they don't understand, it's because I hadn't been as clear as I ought to be from that standpoint. And that's the reason I like to have communications where I can see the person's face is for that very reason. You would hope and think that when, even over the phone, if I say, do you have any questions? If they do, they will ask. But some people are, they may not, or they may think they understand and they don't, and I can tell that they don't when I'm talking to them.
Well, you mentioned the fact that you can do a video call. I mean, I think a lot of people are used to FaceTime and things like that. If you use Facebook and things like that, but actually in hearings now, I mean, the workers' compensation process can also be done to some extent via video call, right?
Yes, and it is frequently now. We do it by Zoom. Workers' comp uses the Zoom process so that the judge. I've got one scheduled actually now. The judge will be in Pikeville, the defense attorney will be in Owensboro, and my client and I will be in my office in Murray. And that's that's actually not that uncommon. A lot of times the defense attorney may be in Louisville or Lexington. Judge is in Bowling Green, and my client and I are in my office in Murray, or the client may be in Louisville from that standpoint. So it just varies from situation to situation. But that's one thing that developed as a result of COVID. When everything shut down, the Department of Workers' Claims flipped over to using Zoom fairly quickly. And it stuck around because it actually saves taxpayers money, because the judges don't have to travel as much, and they don't have hotel rooms, they don't have mileage, and it makes it more convenient for a lot of folks.
Well, I would think if I'm injured, the last thing I want to do is get in the car and go for a long car ride, depending on the type of injury I have. So if I could do that over the phone or on a video conference, it might actually be even more convenient for the client, the injured worker. Which is another reason they can call down to Murray or down to Hopkinsville and actually get in touch with you and say, okay, we can do this, and it'll work out just fine.
Excuse me. Yes, that's exactly right. Even people, I like the video conference. Zoom is the one I prefer. You've got Microsoft Teams and others as well. But I like to use that because, as you know from talking to me, I'm kind of a hand stalker, and I like to have my hands free. I also like to make notes, and so if I'm on a call where I'm holding the phone and talking to people, it's not. I'm much more comfortable where they're on the computer. But even I have clients who don't have a computer or don't have a internet connection, a good internet connection, but they have a cell phone connection, and we can do that through. If they got a smartphone, it's easy to download the app, and we can do the Zoom that way as well, and it works out well for clients. So
that's good news. That's good news, Jeff. I really want to thank you for your time. I appreciate it anytime we can get together, and you do a lot of preparation for these episodes, and I really appreciate the fact that you kind of get into it and work through it. And again, the reason we're doing this is to try to take these complex topics and make it very understandable and accessible, so that if you have questions, maybe this points you in the right direction. But always pick up the phone. Jeff gives free consultations. I mean, you get some basic information based on your discussion with him, and you can make a decision. Look, should I move forward? And if I should I have Jeff lead the charge? And it's always nice when you can talk one-on-one with an attorney and really kind of get used to how they're going to communicate and get a good feel for, hey, is this going to work out in terms of, do we kind of get together, and do I think Jeff gets me, and do I get Jeff, in terms of the information that we're trying to exchange here. So it's always good. Friends, from all of us at the Roberts Law Office, where they deliver small town service and big city results, thanks for listening. Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.